More than just a home inspection. Most buyers and their agents understand the importance of a home inspection to discover physical defects in a property. However, there are other due diligence investigations that a buyer should undertake when purchasing a resale property. Note: much of the following is also applicable to new home sales. However, in new home sales, the buyer will generally have no opportunity to cancel the contract if the buyer disapproves of an item discovered after the contract is signed. Therefore, these due diligence items should be undertaken before signing a new home contract. Read the title commitment within 5 days after receipt. The contract instructs the escrow company to deliver a title commitment to the buyer. The title commitment tells the buyer whether the taxes and assessments are paid, whether there are deed restrictions, liens and easements on the property, and what the requirements are to the issuance of title insurance on the home. The Arizona Association of Realtors, AR. Residential Resale Purchase Contract allows a buyer 5 days after receipt of the title commitment and all documents that will remain as exceptions to the buyer's policy of title insurance to provide the seller notice of any of the exceptions reasonably disapproved. Upon receiving the commitment, the buyer, with the assistance of the buyer's agent, should read Schedule B of the commitment, which lists the specific items of record that the title examiner has determined to be encumbering the property and are therefore exceptions and exclusions from coverage. Schedule A is the boilerplate statement of what is not covered under the policy. The buyer should review all of the documents listed in Schedule B of the commitment, which may include easements, patents, deeds, and liens. If there is a question about any of these documents, the buyer should call the title or escrow officer or a qualified attorney. If an exception is unacceptable to the buyer and agent may be able to convince the title company to remove it, insure over it with an endorsement, or clear it by obtaining a release, affidavit, waiver, quitclaim deed, or other appropriate documents. However, if the unacceptable exception is not discovered and objected to during the inspection period, there may not be time to address the unacceptable exception, and the buyer may be forced to close escrow subject to the exception. Read the CC&Rs and other HOA governing documents within 5 days after receipt. If the home is located in a homeowners association, HOA, condominium complex, or planned unit development, the buyer, with the assistance of buyer's agent, must read the CC&Rs, other governing documents, and the disclosures required by law within 5 days after receipt. If the buyer reasonably disapproves of any of these restrictions and rules, the buyer may give the seller written notice of the items and exercise the right to cancel. Many CC&Rs contain a table of contents, which is a good place for a buyer to start a review of the document. The CC&Rs are likely divided into various sections, such as definitions, developers' rights, use restrictions, easements, membership, voting rights, assessments, fees, penalties, maintenance responsibility, and insurance. At a minimum, a buyer must thoroughly understand the use restrictions, since these may affect the buyer's day-to-day life in the community. At times, there are questions about the scope of a restriction, or whether a restriction has been waived. The buyer should be encouraged to clarify these issues with the HOA, management company, or legal counsel within the 5-day review period, or provide the seller with written notice of disapproval. Apply for homeowners insurance immediately and obtain a written commitment during the inspection period. The buyer should apply for homeowners insurance and obtain a written confirmation of the availability and cost of homeowners insurance for the home during the inspection period. Many factors affect the availability and cost of homeowners insurance. Depending on the insurance company, these factors may include past insurance claims filed on the home, past insurance claims filed by a buyer, and the buyer's credit report. The buyer should be informed that the home's claims history or CLUE report will not provide all the necessary information to determine if the home is insurable, since not all insurance companies use this information or use it in the same manner. Therefore, if the buyer is not satisfied with the cost of insurance from one company, the buyer may want to shop around before concluding that the home is not insurable at a reasonable price. However, if the buyer ultimately determines that the cost of homeowner's insurance is unreasonable, the buyer may cancel the contract if notice is given during the inspection period. Investigate building code violations during the inspection period. If the home has been recently remodeled, the buyer should be encouraged to verify that the proper permits were obtained. Residential construction permits are needed when existing homes are remodeled or additions are made. For instance, in Phoenix, a permit is needed for improvements such as room additions, garage or carport conversions, porch enclosures, patio covers, detached garages, sheds, gazebos, or structures that are larger than 120 square feet in a roof area, fences or walls that are higher than 6 feet, retaining walls over 4 feet high, installation or alteration of a driveway, remodeling, repairs, or additions that require electrical, mechanical, plumbing, or structural changes. To determine whether the required permits were obtained for a home remodel or addition, the buyer should contact the City Development Services Department during the inspection period. If the buyer determines that the proper permit was not obtained, the buyer can give the seller written notice of disapproval. And if the buyer does not elect to cancel the contract, the parties can work with the city to obtain the permit, assuming that the remodel or addition was performed in compliance with the then existing construction code. Other investigations may be warranted. Depending upon the particular home or the buyer's particular concerns, additional due diligence investigations may be warranted. The buyer may want to verify property boundaries, property setbacks, the presence of sex offenders in the vicinity, quality of schools, area crime statistics, and a myriad of other issues. A good buyer's agent and the buyer advisory can assist the buyer in identifying the issues to be investigated and completed the buyer's due diligence within the time periods provided for in the contract. Avoid using on or before in contracts. On or before is often included in contracts to show that performance may be completed prior to the deadline date. When submitting or accepting an offer, there are many scenarios in which it might seem prudent to insert this verbiage before the close of escrow date. For example, a home has to sell before a new home can be purchased, or the parties are hoping for a quicker close of escrow than the designated close of escrow date. Regardless of the reason, do not do it. Inserting additional language into the contract, such as on or before, may have unintended consequences. Consider the following scenario. In order to purchase a new home, the buyers must sell their current home. The sale is scheduled to close escrow on August 1, 2016. Subsequently, the buyers submit an offer on a new home, requesting to close escrow on or before August 4, 2016. The buyer's offer is accepted. As luck would have it, the buyers are able to close escrow on the sale of their home 1 week early. The buyers are now demanding the seller close the transaction before August 4th. Unfortunately, the seller cannot possibly be out of the house by then. The buyers are upset, and both parties have decided to consult legal counsel. The best outcome for the above scenario is that the parties are able to close escrow early. However, the worst-case scenario could involve a lawsuit with claims for breach of fiduciary duty against each party's agent. The outcome? It depends. In spite of the uncertainty of a lawsuit's outcome, you can be certain a lawsuit will cause anguish, take time away from your business, and cost money. Therefore, the best practice is to have a definitive close of escrow date so that the parties' expectations are managed accordingly. If the parties thereafter mutually agree to a different date, the parties can amend the contract.